Hey, everybody, and welcome to Thursday night. All right, John Skiba here from the Consumer Warrior YouTube channel. Thursday night, we're here once again doing the live Q&A that we do each and every week, talking about all things debt-related. And as I always do, I give my little spiel at the beginning that I am a licensed attorney in the state of Arizona. I work for the law firm of Jackson White here in Mesa, Arizona, where I do bankruptcy and debt collection defense representation. However, I'm not licensed anywhere else. So if you're not from the state of Arizona, I can't give you any legal advice, and you need to take this for what it is, some dude talking on YouTube. And if you need legal advice, I highly, highly recommend you contact an attorney in your particular state. If you're in the state of Arizona, you can look below this video and you're going to find my contact information. I'm happy to set up a consultation where I can do a one-on-one type consult and kind of steer you in the right direction at that point. So before we jump into the questions, and we already have a whole list of questions, you're going to keep me busy tonight. I want to go over a couple things. I am going to bring up the fact that we did start the Consumer Warrior community. I showed some of the most recent events. I do some videos and some tutorials that are specifically only for members of the Consumer Warrior community. I will put a link again below this, and I'll try to throw it in the notes here as well, where you can sign up for that. We just did one on how to cross-examine a witness, where I gave out my whole script of everything that I do when I go to trial against junk debt buyers. And then I also did one back on the 17th on excluding debt buyer documents as hearsay, both in the summary judgment context as well as in the trial context. So you can take a look at that and see if that would be a benefit to you. I'll go ahead and do that right now. I'm just going to throw that a little comment here. So if you want to have any interest in that, you can click on that. I just put that over there in the notes. One thing I also I pinned it to the top of the comments over at YouTube. I put out a video today. If you're in the state of Arizona, there's a proposition that's on the ballot for November 8th called Proposition 209. And I've had a lot of people reach out to me and ask kind of what my take is on it. And so I did a whole video on it, and it's something that's really huge, particularly in this field that I work in, because this proposition would change the exemptions. These are the laws that protect your stuff when you're going through bankruptcy. It protects it from creditors, including the homestead exemption, and it reduces the amount of garnishment, the amount of wage garnishment that can happen in the state of Arizona. Takes it from 25% down to 10%. And people in a certain income bracket, it actually eliminated it altogether. I was at a creditor symposium, and the reason why I go to this is because every year they put on this creditor symposium, and I like to go hear what the other sides, what their strategies are. So I attended, and they are obviously against it. And they said that they thought that if this passes, it would effectively end 60 to 70% of all wage garnishments in the state of Arizona. So this could be a pretty huge thing. And I recommend go watch that video. Again, it's linked up, pinned at the top. And it's a little bit longer video than I normally do, but I kind of walk you through what it is and why I think you ought to vote for it. All right. With all that being said, let's jump into the questions. Hey, we got Spider Boy Games here. Thank you for supporting the channel. Also showing up as a new YouTube member of my YouTube channel. Thank you so much. And I saw you had some questions right here. You said, what is the best way to deal with a debt scavenger who has threatened a lawsuit on a 15-year-old debt that is paid in full? I like that, a debt scavenger. The debt collector in question is ran by Lamont D. Cooper, who has a history of using illegal tactics, but uses all the burner phone numbers, temporary websites, changes name of his CA. They have been harassing me for the past 3 months. Again, this is well beyond the state statute of limitation, and it's paid in full. Thanks. This is a good question. I can tell you this. So often, so there is a law called the Fair Debt Collection Practices Act, the FDCPA, this federal statute that applies against debt collectors that states that, they can't do some of the crazy things that Spider Boy here is telling us that they're doing here. I always say that there's kind of a sliding scale, it seems, in the debt collection world. To the more egregious the behavior, the less collectible the people are. And a good example is one time I had a client who they were being harassed, just outrageous stuff by this debt collector who's they're out of the state of New York. And they were calling my client in Arizona. They were saying that they were sending the sheriff over to pick them up for this debt that they were claiming. They were saying that they were sitting outside their house, waiting to take them to jail. Just horrific stuff that's totally and obviously illegal. And so, as a young lawyer, I remember I got that case and I was thinking, sweet, this is a slam dunk. We're going to go after these guys. We're going to make them pay. We're going to make them stop. And they're going to pay my client $1 billion and it's going to be awesome. And so I filed a lawsuit in federal court here in Arizona, and I actually found the place. I did a Google Earth search, found the location of the debt collector, and I filed a lawsuit, hired a process server in New York, and sent them to serve them with a copy of the complaint and the summons. Process server got back to me and said, the place is empty. And I was like, what are you talking about? I talked to this guy on the phone. I confirmed. I mean, we literally had like a Google Earth screenshot. I could see the name of the company, the law firm. And he said, it's empty. There's nothing in there. Place is vacant. And I finally got hold of the attorney who worked in-house for this debt collector. And he literally said to me on the phone, he's like, you don't understand how this works. He goes, you sue us, we'll pack up, move to somewhere else. He goes, basically saying, screw you guys. We're not, we know what we're doing is illegal and we don't care. And so the behavior was super egregious and they were causing lots of harm. But the trouble was there was a very limited things that we could do as consumer attorneys to stop it. So if the behavior, this is a long story, Spider Boy games here but here's what I often recommend. Because the only time I go after a party for FDCPA is if it's a legitimate collector. We can tell that they're members of the American Creditors Association. We can tell that that means they're licensed. It means they have insurance, and we can actually get somewhere with it. I don't want to go down some rabbit hole of something like that again, where you're just trying to chase these people all over the state and they're operating out of somebody's basement somewhere. And I don't want to do that. And that doesn't benefit you. That doesn't benefit me. There's no reason to do it. So usually in those situations, that's why I recommend people do contact out to state agencies. Like in Arizona, there is the Attorney General's office has a consumer division. They have the resources as far as manpower and access to be able to kind of chase these people down and go after them more than a private attorney would. So that's usually what I recommend in a situation like that. If you know that it's outside the statute of limitations, 15-year-old debt, and you're even saying it's paid in full in your prior comment, that's going to be probably your best option. You can find someone, if there's an FDCPA attorney, maybe they have more experience with this Lamont Cooper and that they know a tactic. I would look up an FDCPA attorney locally there. And if not, then contact like the Attorney General's office and see if they have some kind of consumer division like I was talking about. So I know that's not very, that's kind of frustrating as far as the response goes, but that's the reality of it a lot of times. So, all right, let's see here. Taylor was here nice and early with this question. So let's jump in on this one. How could I word a debt settlement with a debt collector without restarting the statute of limitations on it? I'm considering telling them I'm going to declare bankruptcy, Chapter 7, but if they will accept bankruptcy, Chapter 7 fees, I will pay them that amount. Okay, and that's not a bad strategy. I tell people that as far as that, look, you can approach the debt collector and say, hey, it's going to cost me whatever, $2,000 to file bankruptcy. I'll pay you that, or we could just settle it because they'll get zero in a bankruptcy type setting. To this question more specifically, how you're saying, how do you word it? It'll depend a little bit on the state that you're in. Usually just offering a settlement alone is not enough to restart the statute of limitations. The Arizona Supreme Court did recently, it's been a few years now. They did a case where they actually went through this, and it was such a breath of fresh air because there's so much gray area, and they really solidified, at least in the state of Arizona, and said, look, the only way you restart the statute of limitations in Arizona on credit cards and debts like that is to bring the account completely current, So, if you have a $10,000 credit card and you're behind $2,500 on payments, making a $10 payment to the creditor does not restart the statute of limitations. You're still in default. They could still sue you. The only way they said that you could restart the statute is if you paid the full past due balance, brought it current, and then the creditor's not in a position to be able to sue you because you're not behind anymore. Or if you just acknowledge the debt in writing. And that's where we get a little bit of gray area where, if you reach out and you acknowledge the debt, basically send them a letter saying, yes, I owe this. I'm going to pay it. Here's my plan. But reaching out and just saying, I'll give you $200 for you guys to go away. There's a lot of reasons why people would offer a settlement just to get everything to stop. So if you're in Arizona, just reaching out and offering a settlement, that's not going to restart the statute of limitations. And like I said, I think that your strategy of trying to deal with the debt and saying, hey, I'm going to file bankruptcy or I can pay you what it's going to cost me. I can tell you there's a bit of crying wolf when it comes to bankruptcy. The debt collectors, that's what they hear all day long. And so the big collectors often will say, go ahead and file. They don't care. So, but what the approach you're taking is not a bad one. So, all right, let's see. Wally says, is there a time limit during the discovery phase? Next Monday, there will be a 40 calendar days since I filed my answer and nothing has been added to the case and they haven't contacted me. What should I do? Well, there's a couple things. Depending on which state you're in, there may be some disclosure rules. Like in Arizona, 30 days after the filing, the parties are required to exchange disclosure statements, which are documents and lists of witnesses and defenses and claims and all that kind of stuff. And though in Arizona, those are not filed with the court. They are just exchanged between the parties. The discovery phase in most litigation matters, eventually the court will set a discovery cutoff, or sometimes the rules of civil procedure will say that discovery ends, 90 days before trial or 120 days before trial. So you might want to look at the rules the rules of civil procedure in your jurisdiction. Discovery rules are usually in the low 30s, 32, 33, 34, 36, right around there, depending on your state, where you can take a look at that and see if there's something specific as far as when the discovery cutoff is. If it, and I should say this too, like true written discovery, whether it's, interrogatories, requests for admissions, requests for productions, there is no requirement that the parties engage in that at all. I've been in numerous cases where neither of the parties did any kind of written discovery. So they don't have to send you something, but usually when it comes to disclosures, those are required. They have to, there's no trial by ambush. They have to be able to provide you with the documentation and information that's necessary to be able to prepare your defense. So, all right, let's see what 5.0 newbie has to say. I really want to thank you. LBNB filed suit against me. I filed a motion to compel arbitration. LVMV's attorney filed an answer to the motion. 2 weeks later, received a letter that they are dismissing with prejudice. So thank you for your insight. Awesome. I'm glad to hear that it worked. And with prejudice, that's awesome. That means that they're not going to, and like I said, what you did right there, they do this cost benefit analysis. You got to remember, like particularly a junk debt buyer like LVMV funding, they're there to make money. They are, there's no, sometimes they act like they're they're there with this righteous cause of debt collectors. They're there to make money. And if they're not going to make money, or if you're going to cost them a bunch of money, they'll move on. They have tens and hundreds of thousands of other cases that they'll go ahead and pursue. So, all right, let's see here. Let's jump in with Al. Thanks, John. Sorry I didn't make Monday's masterclass. I was celebrating our wedding anniversary. I did watch the recording of it, however. Awesome. You mean you did for your anniversary? You didn't want to watch a little how to cross-examine a junk debt buyer witness? Happy anniversary. Congratulations on that. And as far as what Al's talking about here, we do, like I said, with the Consumer Warrior community, I'm doing these master classes to really show you how to do different approaches and strategies that are much deeper than we can get into here on the weekly live stream or even the YouTube videos. I also provide some of the scripts and I provide some of the documents that I use in my practice that are helpful. So, all right, let's see here. Ivan says, what can I do if the original creditor wants me to pay for arbitration since I brought it to the motion to compel arbitration and the judge granted the their request for the defendant to pay for this. So if it's private arbitration you're going to, and the court says, okay, you've got to pay it, that's fine. I've showed before on my videos in arbitration, because you're going to either be going to AAA or JAMS. Those are the two private arbitration companies in the United States. Go to their website and look at what the filing fees are for you as compared to the creditor. It's night and day difference. So like with AAA, I believe like the consumer, the most you're going to pay is somewhere between $100 and $200. The creditor has to pay several $1,000s to get the case. Even if they're the ones who are, bringing the claim, they've got to pay a much larger filing fee. They've got to pay some of the arbitrator's fees up front. And then there's usually some type of case fee that they have to pay. So it's going to cost you a little bit of money, but at the end of the day, if you initiate that, I still think they're going to dismiss. And the court too, it's kind of interesting if the court is telling them requiring the defendant to pay for it. The court doesn't have any jurisdiction over who pays what in private arbitration. It's being booted out of the court altogether. And so they shouldn't be able to dictate that. You also ought to go back and look at your arbitration clause, because often the arbitration clause will tell you who has to pay what. And sometimes it'll even say the creditor is the one who has to pay it. Or sometimes it has this weird language in there that says, if you ask us, basically, if you ask us nicely to pay this, we'll do it. So you make sure and go look back there, look at that, what it is. Worst case scenario, I would say go ahead and pay it, because I think in the end, you're going to be money ahead. So, all right, let's see. Matt says, if an owner of a debt files a lawsuit before the end of the statute of limitations, does he also need to serve the debtor before the statute of limitations expires? No. The filing of the lawsuit is what's necessary to meet the statute of limitations. Now, like in Arizona, they do have a time period to serve you. So they file the lawsuit. As long as it's before the expiration, like in Arizona, it's 6 years. As long as it's before the expiration of the 6 years, then they have, depending on whether in justice or superior court, they have 90 to 120 days to serve you with that. But no, if they have filed it, but it's the filing of the lawsuit, that timestamp that you see on the document, that's going to be what matters when it comes to statute of limitation. So, all right. Johnny from Mass says, hi, I was served by JP Morgan Chase for $9,000. Should I file a motion to compel arbitration and dismiss from the court? You need to get a copy of the terms and conditions. And again, if you don't have it and they haven't provided it to you, you can go to the Consumer Financial Protection Bureau's website, and under resources or like education or something, they have a whole database of all these terms and conditions for credit cards. So you can look up your specific card, even the year, and take a look at it there. If there has to be an arbitration clause to be able to do it. I've had some people misunderstand that they think, oh, you can just do it with anything. There are some credit cards, particularly newer credit cards. I think it was Bank of America, I've heard, in their newer ones, they've gotten rid of those arbitration clauses. So you want to go and make sure that that's there. But yeah, if it's there, you could do the same thing, same thing as a junk debt buyer's original creditor. With a junk debt buyer, you're just enforcing the original creditor's arbitration clause. So you can absolutely do that. So really quick, here's that plug I did. I'm just going through the comments. The one I posted, the link to where you can sign up for the Consumer Warrior community. So, all right, see what George has to say. I had to file my answer to defend last week. The court date is December 2nd. Can I file a motion to dismiss and compel private arbitration before the court date? Yes. My recommendation is you do it as soon as possible. Usually those arbitration clauses will state something like you've got to request arbitration prior to the entry of judgment. I've even seen some clauses that say that has to be filed before trial begins. I can tell you this, if you stretch it out and file it the day before trial, judges are not going to like that. And you run the risk of having a bad ruling there. So I would file it now. I would get it in there. Not only that, so you're filing it now, and then the other side's going to have a chance to respond. They're usually going to have somewhere between like 10 and 15 days to respond to it. You want to get that done sooner than later. So, all right. Let's see here. These interest rate hikes are killing me. I use my credit cards to buy inventory. Usually there's about a 3-month window here. I float the purchases and able to sell for a nice profit. Maybe this wasn't a question. It's good. Everybody's communicating in the chat area, and I'm just throwing it up on here. So, all right. Hey, Nathan's brought up the fact that, about, like I said, the new homestead exemption in Arizona hasn't passed, but if it does on November 8th, it'll bump it from 250 to 400. Nathan's saying in Maryland it's 27,000. I don't, it's crazy. And, I was looking, New Mexico is bad. It's just weird how it varies so much. Like Maryland, $27,000. I don't know. I'd be interested to talk to the bankruptcy attorneys out there, how people file for bankruptcy and don't lose their home. It seems like everybody would lose their home with the homestead exemption that low. So, all right. Triple Crown's asking, is the best way to find an attorney for Chapter 7 to go to the State Bar Association? Thank you for these Q&As. Where I would go is there's a group that I'm part of called the National Association of Consumer Bankruptcy Advocates. Let me just pull up the this is not good video here for me just to sit here silently. So NACBA, the National Association of Consumer Bankruptcy Attorneys, is a group. It's a private, kind of like a trade group that we do. I'm going to put a link here to it. It'll have an attorney finder section. If members of if a bankruptcy attorney is a member of NACBA, bankruptcy is what they do. It's a trade organization that does education and things like that. So you can go there. I just put a link there to NACBA. They're going to have an attorney find. That's where I would go, because you're going to find someone who's not just dabbling in bankruptcy. That this is what they do for a living. They focus on this. They'll know the statutes. An interesting thing you bring up. You'll say you'll be moving to a new state in 1 week. To file bankruptcy in a particular state, the law says you have to have lived there the better of 180 days. The better part of 180 days. And how the courts have interpreted that, you have to live there at least 91 days. So just so you're aware, and make sure that the attorney that you hire is aware that you've just recently moved into that state, because you have to live there for at least 91 days to be able to file in that state. Not only that, you're going to have to use the exemptions from the state that you're coming from. And that you have to live in a state for 2 years before that changes. But 91 days and you can still file the case there. All right. This one says, if I file Chapter 7 bankruptcy, can my car be taken from me? I still owe $37,000 and the car is worth $45,000 and I live in Florida. So in the Chapter 7 bankruptcy, the idea behind it is it's going to get rid of most of the unsecured debts, credit cards, medical bills, that kind of stuff. Secured debts are treated differently, usually in bankruptcy. Typically, you can keep the houses, the cars, as long as you continue to make the payment. And as long as the amount of equity you have in there, so we're taking the value of the car minus how much you owe on it. So in a situation like this, the cars were $45,000, you still owe $37,000 on it. So you're looking at $8,000 of equity. You need to look up what the exemption for vehicles is in the state of Florida. I don't know that off the top of my head. So you need to look. So like in Arizona right now, it's $6,000 of equity. So I don't know if Florida, I'm sure Florida is different. Sometimes this is where it's helpful to go talk to a bankruptcy attorney, because some states are a little tricky. Like they may have maybe they have like a $5,000 vehicle exemption, but then they also have like a $5,000 wild card exemption. You could stack those. Those are things I don't know, not practicing there, but you may be able to. So, but the first thing is you have to continue to make the payments on it. I tell everybody there's no free car, there's no free houses in bankruptcy. You got to still make the payments. But you got it in a situation like that where there's equity in the vehicle, you really need to have someone who knows the exemptions in that area just to make sure that you're not going to lose anything before you jump into it. That's one of the big changes in that Arizona Prop 209. It takes the $6,000 Arizona exemption and creates a $15,000 exemption as far as equity goes in a vehicle. And that would be a huge change. So, all right. Monica says, I was granted a motion to compel arbitration. Haven't heard anything since then. Judge has chamber work for post-arbitration. What happens then? So a lot of judges will do this if the motion to compel is granted, and then neither party initiates arbitration. They essentially stay the litigation and say, okay, let's in 90 days, we'll set a status hearing and see where it's at. Here's my opinion on this. If it were me, if I'm being sued and I ask the court to do an arbitration hearing on it, and the court says, great, go do it, we're going to stay it. If the creditor didn't initiate it, I would file a motion to dismiss with the court, and I'd file a motion to dismiss with prejudice. And here's my thinking on this: the creditor is going to come in and say, "Well, we didn't ask for arbitration. Why would we initiate it?" And my response is, because you have the claims. It's you guys who are suing me. Why would I go file a lawsuit against myself, either in a court or in arbitration? That you wouldn't go in and say, hey, court, I'm filing this lawsuit against myself because I think Midland Funding thinks I owe them some money. It doesn't make any sense. And so they're the ones with the claim against you. They need to initiate it. All you're doing is asking the court to enforce the provisions in the arbitration clause that say you get to essentially choose the venue, that you don't want the venue in court. You want the venue in private arbitration. You're saying, okay, debt buyer or whoever's suing you, this is where we're going to solve this issue, is in arbitration. So you need to initiate it here. So I would file a motion to dismiss and say, Judge, you said, okay, go. You granted my motion. They haven't done it. They're just sitting here doing nothing. Please dismiss the case and dismiss it with prejudice. They had their chance to do it and they didn't pursue it. So that's what I would do. All right. Mama's the boss. Can you file for bankruptcy on an overpayment on unemployment? Yes. Super easy one there. Unemployment, overpayments on Social Security, any kind of overpayment. It's always weird to me how these things happen. Is nobody in the government watching I've seen overpayments that are gigantic. I mean, tens of thousands of dollars, and then they send a letter, and it's usually like a long time after they happen. Hey, sorry, we overpaid you $40,000 a year and a half ago. Can you send that back to us? But yeah, absolutely, you could include that. It's not like a tax or like a civil penalty or anything. You absolutely can get rid of it in a Chapter 7 bankruptcy. All right, Michael Wells here says, just purchased a car financed by Santander and wanted to file Chapter 7. Have a $32,000 in collection accounts. I want to keep the car, but don't want to reaffirm that. Will that be a problem in Las Vegas? I don't know. I'm not licensed in Nevada. I went to law school there, but I don't know. I'm a UNLV grad from UNLV's law school. I don't know if you, well, let me tell you this. A couple issues that if you're talking to the bankruptcy attorney, these are important facts to bring up, and I'll tell you why. In Arizona, if you bought a car recently and need to file bankruptcy, you need to make sure, like in this case, the Santander has put the lien on the title to your vehicle. In Arizona, if you file the case, and I know Nevada's in the Ninth Circuit, just like Arizona is, there's Ninth Circuit case law that says that the trustees can come in, disregard the exemption, and just sell the car free and clear of any liens. I had it happen early on in my career. And so this is one of those ones, anytime a client tells me, hey, I bought a car over the last 3 months, I always go to the DMV and say, hey, we need to get a printout and make sure that lien has been affixed. The reason why is because once the bankruptcy is filed, they can't go in there and affix their lien. It's a violation of what's called the automatic stay. So you need to make sure that the lien's there so that you can just, like I was saying, you can start making those payments on it. The question of reaffirmation can be a little bit tricky. I can tell you what happens in Arizona. I don't know how the bankruptcy judges in Nevada handle reaffirmation agreements. The reaffirmation agreements on car loans. So the bankruptcy code says this. It says, hey, if you have a car loan and you want to keep the car, you need to reaffirm it. So essentially you're entering into a contract after the bankruptcy has been filed that says, I'm going to keep this vehicle and I'm going to continue to pay on it. And here's the terms. There's 3 parts to reaffirmation agreement. The creditor has to sign it, you have to sign it, and then the judge has to approve it. Arizona judges are not big fans of reaffirmation agreements on vehicles. The reason why is they think they're dangerous. They don't think that they're in the bankruptcy debtor's best interest, because if they approve the reaffirmation agreement and then let's say something unforeseen happens and 6 months down the road, year down the road, you lose the car, you can't pay for it anymore, the creditor is then permitted to come and sue you for the balance that's still owed on that reaffirmation agreement. If the court doesn't approve the reaffirmation agreement, then if you lose the car, they can repossess the vehicle, but they can't sue you for the balance. So often in Arizona, the courts do not enter into what's called into the reaffirmation agreement. Well, the parties will sign it, but the court won't approve it. And the court will enter an order that says, look, just go ahead and keep making the payments on the car. And as long as you do that, you're fine. And if it has to go back, then you don't owe anything. Here's the dangerous part of that. Well, I shouldn't say dangerous. Here's the annoying part of that is if there's not an approved reaffirmation agreement, the creditor does not have to report any information to the credit reporting agencies, to the credit bureaus. They don't have to report on-time payments. They just report nothing. It's as if nothing's happening, nothing negative, nothing positive. And so a lot of clients get really frustrated with that because they want what they perceive as the positive credit bump of making those payments on time. I can tell you, I have talked to credit experts, people who've worked for the credit reporting agencies. They said post-bankruptcy, just having a single car payment like that wouldn't do that much anyway. So you need to talk to, that's my long way of saying, talk to a Nevada bankruptcy attorney specifically. Because those types of things, Nevada is real close to Arizona, but sometimes things like that and the way judges treat things can be radically different. Alex is here, my man. Thank you. Says, if your spouse has debts in their own name and passes away, can the creditors go after you since the debt is a community property? Supporting from Yuma, as always, I appreciate that. So Arizona is a community property state. And there's, I believe, 9 community property states in the country, and it makes things a little bit more complicated. The idea behind the community property laws are assets and debts that you get while you're married are typically considered joint. So this can protect you if your spouse, if I go and buy a new car on the way home from work tonight, I don't tell my wife about it. She is entitled to, ownership in that vehicle as well. So if we get divorced, then she can get half the value of the vehicle or whatever it is. The flip side is she's on the hook for it as well. She's partly responsible for it. So Alex's question says, if the spouse has debts in their own name and passes away, could the creditors go after you since the debt is community property? I can tell you what I see as what actually happens, and then I can tell you what the law is. Because sometimes with community property issues, it's kind of two different things. Usually, if you are not on it, so let's say that your spouse has a credit card and the spouse passes away and you're not on it, you're not an authorized user, it's not a joint card or anything like that, the debt is usually just done. Usually you can just, whoever it is, you can send them notice that this person passed away, and then it's just over. Is there some community liability there? Yes, probably, but I don't see them pursue it. If it's a joint account, then yeah, they're going to keep coming after you. But I don't see them coming in and saying, trying to do some research and saying, look, there was some community liability. So I don't see that as being a very big issue. So, all right, let me see here. Let's see what Joe has to say. If I file Chapter 7 and I'm on the title of the car with my spouse, does that mean they can only take half the worth of the car? So depends on what state you're in. In Arizona, no. If both of you are on it, and this goes right along with Alex's question there, it's a joint asset. So they'd be able to go after. It also depends on if it says, so if I file Chapter 7, I'm the title of my car with my spouse. Typically, no. But again, this gets a little bit state specific because you have to look at 2 exemption laws, how those work. Like in Arizona, the vehicle exemption applies whether you're in or out of bankruptcy. So in a case like what you're talking about here, you would have an exemption, your spouse would have an exemption, even though they're not filing. In Arizona, you can stack them. So right now it's 6,000. You could put them both on there, even your non-filing spouse. So you could do that. Let's see here. Can I file Chapter 7 bankruptcy if I owe the casino money? Yes, you can file bankruptcy. I guess your question is, does the money go away? Yes, it does. I'm going to admit I don't know a whole lot about casino markers and all that kind of stuff, but it's no different than any other debt, unless they have some type of security with it or something like that. But yeah, if there's, I don't know if there's other I don't know if there's other issues with that. I guess it kind of depends on what kind of casino we're talking about here, but yeah, that debt would go away as well. Triple Crown says, can a bankruptcy court deny Chapter 7 for medical debt? So the rules behind denying discharge on a particular debt, typically the creditor has to come in and object to the discharge of their particular debt going away, and they have to have a reason. And there's all these reasons under 727 of the bankruptcy code and 523 of the bankruptcy code. There has to be one of those reasons. I can't imagine one for a medical debt. I mean, usually it's things like the debt was incurred through fraud, or there's some kind of, it's some kind of tax obligation or penalty. Or I can't imagine that for any. I can't think of a scenario where that would apply to medical debt. So medical debt, one of the big reasons people file bankruptcy, and it usually goes away completely. See what this one said. How long till after the meeting does the discharge occur? I'm assuming you're referring to the discharge, the meeting of creditors. Usually it's 60 to 90 days. In Arizona is usually about 60 days. So, all right. Let's see here. See what Tyrone has to say. Chase filed a lawsuit. I filed a motion to dismiss and move to arbitration. Then Chase filed a motion to stay. If I don't file a motion, if I don't file arbitration, I filed a motion to dismiss with prejudice. Chase filed summary judgment. That's what I'm guessing. Okay. Yep. I found it. Grandma's blowing us up here in the chat. And that's exactly the way Alex says, I need an admin. I do need an admin. I'm running this show all by myself here. So what's your next move? Well, first, if you filed a motion to dismiss, you need to get the court to rule on it. And if they haven't ruled on it yet, and the time for the other side to respond has expired, you could file a what's called a motion for summary disposition. Essentially, you're saying, hey, judge, the time for them to respond to my motion to dismiss has expired. Will you grant it? However, I do say this. You need to see how long you have under the rules to respond to a motion for summary judgment. If you don't get some kind of ruling there, then I would say you need to make sure you respond to the summary judgment. Don't let it go unresponded to. So, all right. I think that is it. Well, let's see. We have, we'll do one more here. This one says, from Gwen says, I have a finance company that was garnished, that has garnished my wages for a car that they repossessed over 5 or 6 years ago. What can I do? If they're garnishing your wages, that tells me they have a judgment. It tells me that they sued you and somehow got a judgment. And so you need to find out how they got the judgment. Were you aware of it? Did they serve you properly? Those are the kinds of things I look at. I start going through and dissecting how did they actually get this judgment in the first place. And if they didn't serve you correctly, you can go in and try to get it set aside. I have a tutorial on that. That's what I think you need to look at first, is how they actually got that judgment. Once the garnishment's in place, it's tough. But it is possible to unwind that if they didn't take those first steps correctly. So, Gwen, what I would do, I would go to the court that issued the ruling. I would go back and get the whole file, and that's where it's time to start just digging through it and see exactly what they have. So, all right, we're going to end that. I've got to go pick my wife up at the airport. So we got to end a little bit earlier tonight. But hey, I appreciate everybody checking in. And again, if you want to become part of the ConsumerWare community, go try that out. There's no obligation for 30 days to do that. And we're going to be doing some additional tutorials. There's some message boards in there where we kind of bounce things back and forth. And if you're in Arizona, check out my video that I posted at the top and see what we can do about the Prop 209 here coming up on November 8th. I think it'd be a big benefit for people in Arizona. But hey, thanks for checking in tonight. We'll catch you next week.